Question from a landlord asking if they have an old lease from 2018 and never issued an AB 1482 notice or a notice of the exemption for Tenant Protection Act for single dwellings, single family homes, condos, etc. Without issuing a new lease. What can they do? Currently, the tenancy is now month to month. Hi, my name is Rob Wells. I'm the Landlord Warrior on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Now, this is an issue that we come up across quite frequently in our office about the exemption from Civil Code Section 1946.2, the Tenants Protection Act, the just cause eviction requirements of the Tenants Protection Act. There are two components of the law. One is governing just cause eviction. The other is regulating rents and so forth. Okay, so this landlord here is asking, they have a tenancy older than from 2018 and they never gave the disclosure. Okay, originally when the Tenants Protection Act came into effect, landlords that had single family homes, that are natural persons or own their properties in a qualified LLC and it's non-corporate or REIT, real estate investment trust owned, they qualify for an exemption under the Tenants Protection Act. They were required to give written notice to the tenants that their tenancy is not subject to the Tenants Protection Act. Hypothetically, under the current version of the law, the landlord still can give notice of that exemption. Okay, what we recommend landlords do, and it's common practice nowadays, is for tenancies that are now month to month, never have the Tenant Protection Act exemption, is to serve the tenant a change in terms of tenancy and add the verbatim disclosure as required under the Tenants Protection Act and serve that to the tenant as a change in terms of tenancy. What that requires is, if you recall, with a change in terms of tenancy that's pursuant to Civil Code Section 827A, you would serve a written notice with the terms of change in terms of tenancy, what are going to be added to the tenancy, and you usually have to give 30 days notice after you, for the new terms to come into effect. Okay, and that notice has to be served just like you would serve a 3-day notice. It either has to be personally delivered to the tenant, it could be served by substitute service, or it could be posted and mailed. Okay, the rules for rental increases don't apply to these changes in terms of tenancy because this is a non-rent rental increase. Okay, it is adding the verbatim disclosure as required under the Tenants Protection Act. So that's how this landlord here could add the provisions of the Tenants Protection Act to their current tenancy without redoing the entire lease agreement. Okay, so for new rental agreements or new tenancies starting after July 1, 2020, at the onset of the tenancy, or when the law says when the tenant, when the lease is renewed, like let's say you do 1-year renewals and you redo it on a separate new lease form, that new lease form has to have the disclosure required under Civil Code Section 1946.2E8. Okay, so landlords, if you're in the Northern California area and you're facing an issue where you don't know if you have the AB 1482 exemption, or if you gave the wrong exemption, you're supposed to give the notice of rights of the Tenants Protection Act and you haven't done that, you're in the Northern California area, you're not sure if you did this or not, and you need some help, feel free to reach out. You can hit our profile down below. You'll go to our website and you can book a free case review session with us to discuss your tenancy issues, or if you have any problematic tenant issue, you can reach out. Okay, put your comments, questions down below. Until next time, folks, I'll talk to you then. Thanks.